So nuisance under law of torts. Nuisance is a specific type of tort that we have mentioned in Unit 3. So what is nuisance? What are the ingredients? Are there any defenses or not? Those parts we are going to discuss.
Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video.
Now, take for example, you are owner of a certain plot of land. Okay, just because you are owner of a plot of land, law provides you certain rights, certain absolute rights, that you can enjoy that plot of land peacefully to the exclusion of others. Excluding other peoples, you can yourself enjoy this plot of land peacefully. That is a right given to you. But if another person, maybe B, C, D, E, whoever, another person interferes with those rights without a lawful justification, that is nothing but nuisance. You are free to enjoy your plot of land freely to the exclusion of others. If somebody else is coming and interfering without a valid justification, that leads to the wrong of nuisance. So what is nuisance? It is sort of unlawful interference. Law does not recognize it. It is not valid in the eyes of law. So it is an unlawful interference with a person's use or enjoyment of land or some rights over or in connection with it. Maybe you are not allowed to use your plot of land. You are not allowed to enter your plot of land to enjoy it peacefully, or some rights over or in connection with that plot of land will be considered as nuisance. So it is sort of unlawful interference by some third person, some outsider. So if a person is having a plot of land, he is having right to enjoy and use that to the exclusion of others. If that right is being violated, maybe through interference by heat, smoke, water, fumes, electricity, disease producing germs, noise, whatever, some kind of disturbance is there, that will be considered as nuisance. Okay, these are common things also, right? If somebody is maybe doing something at their premises, water is coming into our premises, that will be nuisance. If smoke is coming from my neighbor's premises every single day, continuously 4 or 5 hours, that also may be considered as nuisance, right? So all this interference will fall under nuisance because it is affecting my right to enjoy my plot of land. Now, there are mainly two different kinds of nuisance. One is public nuisance, another one is private nuisance. Like, what is private nuisance? It is relating to my private right. It is not affecting the entire society or a larger population as such. That is why private nuisance is considered as a civil wrong. It is affecting my rights or maybe my family's rights, but not the entire society as such. But there may be public nuisance also, which is considered as a crime where rights of a larger number of people are being affected. That will be nothing but public nuisance. And public nuisance is considered as a crime. Okay, is this part clear until here?
Yes, ma'am.
Now, public nuisance is falling under IPC. There are sections 268 that mentions what is public nuisance, and 290 provides for punishment for public nuisance. But this part we need not write in exam. It is only for your understanding. If you want to know, you can read this part, but public nuisance is not needed for the purpose of exam because we are studying torts. This part we will study when we are doing IPC, Indian Penal Code, but not for now. Okay, so what is private nuisance then? Private nuisance may consist of two things. First of all, interference with a person's use or enjoyment of the land. I was owner of this plot of land. I had a right to use this or a right to enjoy this plot of land. If there is any outside interference in my enjoyment of the right, that will be the first ingredient which we need, right? That it is interference with use or enjoyment of the land. Secondly, it may be that some harmful or dangerous things escaped from my neighbor's premises like water, smoke, smell, fumes, gas, noise, heat, vibration, electricity, etc. If those things are escaping and entering my premises, that also will be considered as private nuisance because those will affect my rights to enjoy my own plot of land. Okay, now there are certain ingredients, 3 ingredients that we need to establish or prove before the court. Okay, 3 essentials we have of private nuisance. First of all, unreasonable interference. Yes, I am owner of this plot of land. From my neighbor's premises, water or something is escaping. But then this escape has to be unreasonable. It has to be something which is not a lawful or a legal thing. It's not something that can be justified. It's a wrong. It should not have entered, but it entered. That is the first ingredient, that there should be unreasonable interference. What is unreasonable interference? An interference to which no reasonable man will mind is not nuisance. Now we live in a society. There will be some sort of noise vibration coming in. Okay, maybe you can even hear your neighbors phone call coming, then calling bell ringing, their pressure cookers whistle. All those are like common things, right? Even if it's happening at your neighbor's premises, you get to hear all of it. But those small things would not be considered as nuisance because it is something part of the society. Right? If there are people, there is going to be some minimum noise. So if it is some minimum noise, which a reasonable man would not mind, that is not nuisance. Like somebody's phone is ringing, you are also hearing it. That is some normal thing. That will not be nuisance, but it has to be some unreasonable interference. Might be, this is your house. Just next to your house, there is this marriage hall. Okay, almost every other day there is some or the other function going on. Late at night they would be bursting crackers. It would lead to pollution. Roads would become dirty and all that stuff. That will become nuisance because those sound, smoke, pollutants, everything is coming into your premises. There you can file a case and you can get an injunction order passed that this marriage hall should not allow its clients to basically burst crackers and stuff. Okay, that is unreasonable interference. One time something happening, some minor things, those we can ignore and we anyways ignore that part, right? So it has to be unreasonable interference, first ingredient. Secondly, it should be continuing wrong. It's not like only one day it happened. Only one day might be I was doing some construction or some drilling at my home, so there was some noise. Those parts also we ideally ignored, right? So it should not be like a one-day affair, but it has to be something that is mostly happening only. Okay, but sometimes there may be a situation where even though it's one-time event, it may lead to big damage or big loss. So there it's discretion of court. Ideally, one time event it is not considered, but it is on discretion of court. If court feels like recognizing, it can recognize as well. Those sort of things. Okay, so the first essential that we need is unreasonable interference. Without a valid justification, I am interfering, or my neighbor is interfering in my right to enjoy my own property itself. Okay, is it clear?
Yes, ma'am.
Next is interferences with use or enjoyment of land. We know there is interference, but what sort of interference is it? It should be relating to use or enjoyment of the land. You are owner of this plot of land, but you are not allowed to peacefully stay there, peacefully sleep at night. Or maybe you are not allowed to cultivate something, do gardening and stuff, because water is escaping from your neighbor's premises to your premise, and whatever you want to cultivate, everything just gets damaged. Those will be considered as interference with use or enjoyment of land. You are not allowed to use the land, or you are not allowed to enjoy the plot of land. It can be either of this. And last essential is damage. Damage means some loss you have suffered. It should not be some minor loss, like you were maybe recording something and your neighbor's phone rang suddenly, and because of that you had to do the recording once again. Like ringing the phone call, it's very normal, very usual thing, right? So those sort of damages should not be there, but damage has to be substantial. It has to be like a damage in reality. It's not like some minor thing being done. Okay, these are the 4 essentials which we need to prove in case of private nuisance. But then there are defenses also. Okay, that we can prove these 2 defenses and try to escape the liability. First of all, we can say that I have got prescriptive right to commit nuisance. Prescriptive right to commit nuisance basically means there may be one industry which was set up for like 20 years, it is functioning there in a certain like remote place. One industry is there, it is functioning. After 20 years, after 30 years, I bought a property just next to the industry. And I am going to court and filing a case that this industry is releasing noise, vibration, pollutants and everything, disturbing my peace. Court will say that this industry has got prescriptive right to commit nuisance. That means if some pollution is being done, some noise, vibration is being done continuously for 20 or more years, court will say that they have got a prescriptive right. Nobody asked any question in those 20 years, so now they have got a right to continue doing it. But that does not mean industry can do anything. There are many government guidelines, rules, regulations that they need to follow to ensure they are not polluting the environment as such. So if the industry is following those, it does not matter how disturbing it is for you, you will not get a right. The industry will get this defense that they have got a prescriptive right to commit this nuisance. Okay, and court will also say that you can continue doing it. Because we need industries, we need development, right? We cannot simply say that close all the industries and stay peacefully. That is also not possible, right? That is why prescriptive right will be given to any industry, any factory which is working for 20 or more years in a certain given place. Okay, is it clear?
Yes, ma'am.
Same, and statutory authority we anyway saw in general defenses, right? Same we can discuss here also, that if there is a statutory authority which is getting power from a certain statute, like National Highway Authority of India, if they are constructing a highway and it is causing air pollution, causing disturbance in your travel, in such cases, we cannot say that this National Highway Authority should stop its work, because construction of national highway is important. Even though it is leading to some sort of disturbance, we need to ignore it unless and until National Highway Authority is like negligent or guilty of something, right? We need to ignore those minor nuisance which we have. Same happens, for example, electricity board. Okay, if you are having like a big mango tree just in your premises, but those branches of the tree, it is like it is somehow interfering in those electric wires that are there of electricity board. So electricity people from electricity board would come and they would just cut those branches. Why? Because they do not want electricity to be interrupted because of your tree. There you cannot say that no, don't cut these trees, I want to eat mangoes when it grows. You cannot say that, because it is needed for public good. Rather than you eating mangoes, what is important is the entire locality getting electricity, right? So those will also fall under statutory authority. Same happens for water supply. To provide water supply, they would set up some pipes and stuff. For that, they would just dig the road, break everything, and fix those pipes and stuff. There also, we cannot say that don't do this, because they are getting authority under a statute. Same may happen with road construction department. They would also construct this regular roads. There also, we cannot say that it is disturbing our right. Okay, so all these are defenses that yes, some developmental works we need, those we cannot ignore simply because it is interfering with our right. Okay, now in case of nuisance also someone is interfering. In case of trespass also someone is interfering. But then what is the difference between these two? What is the difference between nuisance and trespass? When we talk about trespass, right, it is sort of direct interference with a person's possession of the land, and it takes place through material objects. It is prima facie action. Maybe I entered somebody else's premises without the person's permission. I went to the person's plot, I planted a tree there. It is like directly I am going there, right? Direct interference is there. But in case of nuisance, I am doing something in my premises only. I am just within myself, but still from my premises something escapes and my neighbor is disturbed. Okay, so it is specifically takes place through some medium, like I am using some electric machines within my premises. It is disturbing my neighbor because of the noise, because of the vibration, or because of the pollutants. That means directly I am not interfering with my neighbor's enjoyment of land, but still it is escaping from my premises to my neighbor's premises. That is the basic difference between trespass and nuisance. Okay, take for example, A cuts the grass in his garden with a grass cutter machine when B took tuition classes in the adjacent building. B was taking classes and A was cutting grasses with a grass cutter machine. The noise caused disturbance to B because he was using this machine. It caused a noise and it disturbed B, who was taking classes in the adjacent building. In this case, A is liable for committing nuisance because he was using this big machine to cut the grasses and it caused disturbance to the neighbor. Right? That will be what? That is nuisance, because A was busy in his own premises, cleaning his garden and stuff, but it disturbed his neighbor. Okay, so this will fall under nuisance. Is this part clear?
Yes, ma'am.